Hi, I'm Reed Bloodworth, the managing partner of Bloodworth Law in Orlando, Florida. At Bloodworth Law, we represent plaintiffs and defendants in many types of civil litigation. At Bloodworth Law, we travel throughout the I-4 corridor. This means we come to our clients and we take care of cases in courts close to our clients. Today, wanted to address breaches of contract and defenses to breaches of contract. So some of the first issues to address is, well, what's a contract? A contract is a fairly simple instrument. It requires an offer, it requires an acceptance, and it requires consideration, which is the item or thing that is bargained for between the parties. Next, a breach of contract. What's that mean? Well, a breach of contract means there was, one, a valid contract, two, that it was breached by one of the parties, meaning one of the parties didn't fully perform his or her duties pursuant to the contract, and three, as a result of that, that party suffered damages. Typically, these damages are monetary in nature. So, what are defenses to a breach of contract? Well, in Florida, there are many types of defenses to breach of contract. I'm going to address several of them in this video. Please understand there are many potential defenses to a breach of contract claim. Here's some of the most common ones. First, the statute of limitations. Statute of limitations means a party has a certain amount of time to file a lawsuit within the state of Florida. For breach of contract, that statute of limitation is either 5 or 4 years. If it is a written contract, the party seeking to enforce their claim has 5 years to bring that cause of action. If it's a verbal contract, they only have 4 years. If the party does not file a lawsuit within the prescribed time period, then they've lost the ability to enforce that contract. The second defense is, was the contract illegal? In Florida, you cannot contract to do an illegal act. Occasionally, people will contract for certain things that turn out to be illegal. Therefore, if a party does not fully perform under that contract, turns out that's okay because it's a valid defense if the contract was illegal. The next very common defense is fraudulent inducement. Fraudulent inducement means that during the course of negotiations, one party was not honest with the other party and they said things, perhaps things that were false, they were lies, in order to get the other party to enter into the contract with them. If this happened, that is a valid defense to a breach of contract case. It's called fraudulent inducement. Next, very common defense for a breach of contract is the statute of frauds. The statute of frauds is a doctrine that states certain contracts must be in writing. And if these types of contracts are not in writing, they're unenforceable. Some of the contracts that have to be in writing include contracts pertaining to real estate, contracts whose performance will take longer than 1 year, contracts that are for above a certain amount of money, and contracts that have to be executed in a certain way. So those are some of the common statute of fraud defenses that can be asserted. The next type of defense involves mistake. You have unilateral mistakes and mutual mistakes. What this means is a contract cannot be breached if the parties that entered into the contract did not understand the terms to the contract. This can take place unilateral, meaning one of the parties to the contract did not understand, or mutual, meaning both sides to the contract did not understand the terms. Finally, a very common defense in Florida is impossibility. Impossibility of performance means that due to completely unforeseen circumstances, such as a death or incapacity or perhaps property destruction, the contract cannot be completed. This is a valid defense to a breach of contract action. As I stated, there are many other types of defenses to breach of contract actions, but these are some of the most common ones. I hope that this video was helpful. I hope the explanations were helpful. Again, my name is Reed Bloodworth, the managing partner of Bloodworth Law. Give me a call. Let's talk about what happened to you.